Lesson 45, Procedure in a Criminal Case. As we know, in criminal cases, the government is always the prosecution, what we call the plaintiff, meaning the party who starts the legal proceedings against another party for a violation of the law. The defendant is the person who's been accused of the crime. A crime is an act that breaks a federal or state criminal law and causes harm to people or society in general. Penal codes establish classifications or degrees of seriousness for certain crimes to set appropriate penalties. The more serious the crime, the more serious the punishment. The most common type of crimes are against property: burglary, robbery, theft, are all forms of larceny, meaning the taking of property unlawfully. Vandalism, the deliberate destruction of property. Fraud, taking property by dishonest means or misrepresentation. Remember my speech in class about the elaborate, sophisticated fraud schemes that people come up with, very professional, fraudulent people. Victimless crimes. These crimes are often argued for not being a crime because there are no victims involved, but they can, in fact, harm others. Okay, so what happens in a criminal case? Let's take you through the due process of an accused. We have an arrest. Police officers make an arrest if they have witnessed a suspected crime or they have secured an arrest warrant from a magistrate judge. They recite the Miranda rights to the alleged criminal. Then we go down for a booking. The suspect is taken to a local police station to be booked. That includes fingerprinting and photographed. Some celebrity bookings, some of whom you may recognize. Then you have what's called a preliminary hearing. This is after being booked. The suspect appears in court and hears the charges against him or her. Preliminary hearing. In some states, a preliminary hearing is used instead of a grand jury indictment. Remember, an indictment is a formal charge with a crime. After indictment, the defendant appears in court for a procedure called an arraignment. Now, this is important. When an accused is arraigned, he's formally presented with the charges and asked to enter a plea. At that point, you have representatives of the prosecution's office, the district attorney's office in the courtroom. You have the defendant's attorney there. The judge says, "You are charged with this crime. How do you plea?" And then the defendant says, "I plead guilty" or "not guilty." If pleads guilty, then the judge assigns the punishment. If the plea is not guilty, then we're going to have a trial. This all takes place at the arraignment stage of due process. Oftentimes in criminal cases, the accused plea bargains with the prosecution or the district attorney's office. In other words, the accused agrees to plead guilty but to a lesser charge. Pleads guilty but to a lesser charge, a plea bargain. This has been all worked out in advance. The prosecution and the defense attorney have all worked this out. So in court, during the arraignment stage, the prosecuting attorney will tell the judge, "We have worked out this agreement. It's an agreement." And the judge listens and mostly all the time accepts the agreement between the prosecution and the defense. Now, why do you plea bargain? Well, the defendant avoids a time-consuming and lengthy trial. It also ensures that a person will be punished for committing a crime. So you get a punishment out of it. The accused will serve a punishment for the crime, for a crime, well, for committing the crime. But it's not. It's a lesser charge. But that's 80%, 90% of our criminal cases are plea bargained. They do not end up in court. I want to repeat this. Most criminal cases do not end up in court. They are plea bargained. It saves the taxpayers a lot of time and money of putting on a lengthy trial. You never know the outcome of a trial. It's hard to predict sometimes. And so this is usually what is done. There you go. Most criminal cases are plea bargain. They rarely go to trial. If the accused does not plea bargain and pleads not guilty, the judge either sends him back to jail or sets bail, and can release him on his own recognizance without setting bail. Now, bail is a security deposit. It's to make sure that the accused shows up for his trial. He'll get his money back when he shows up for the trial, but it's to make sure he shows up. A security deposit. That is bail. Remember, the Eighth Amendment says you cannot have excessive bail. Now, a judge can refuse to grant bail if the judge feels the accused is a flight risk, in other words, may not show up for his trial, or the crime is so heinous, it's so horrific, that you don't want to even enter the possibility of granting bail to the accused because it's such a horrific crime. The defense has a lot of work to do before the case goes to trial, and gathering lots of information, as does the prosecution. Okay, in the courtroom, what happens? Well, we know that if you cannot afford a lawyer, and it's a very serious case of at least 6 months in jail as a punishment, then you can be appointed a PD, a public defender. Now, you could, the accused, speaking on his behalf, could give up the right to have a jury trial and could instead have the judge determine the verdict. We call that a bench trial. A bench trial, when the judge alone makes a ruling in the case without a jury. But most of the time, we're going to have a jury. It's going to be 12 citizens of your peers. 12 citizens in a jury in a criminal trial. The jury has to be selected. You go through what's called jury selection. Both sides are trying to avoid those jurors, those potential jurors who may be unfavorable to their side. Oftentimes, in very high-profile cases, the defense attorney may have a jury consultant. They may hire a jury consultant, somebody who says that would be a good person to throw out. We don't want that person on the jury. Or no, we want that person on the jury. When it comes to jury selection, each side may throw out potential jurors. Each side gets a certain number. They just say, you know what, we don't want him or we don't want her. For whatever reason, you don't have to explain. Once you use up all your freebies that you get to throw out, if you come across a potential juror you don't like, you have to explain to the judge why you do not want that person as a juror. And then the judge has to agree with you, and the judge may disagree at that point. Of course, it is one of our civic duties to serve on a jury when called. Miss, you just can't sign up to be in the next celebrity murder jury. All right, the trial. After the jury is chosen, each lawyer will present their opening arguments. It always begins with the prosecution first. Each side will call witnesses who swear that their testimony will, under oath, will be the truth, the whole truth, and nothing but the truth. Let's try this again, and this time, don't cross your fingers. After the witness testifies, the other side is able to cross-examine the witness. Cross-examine. The questions in a cross-examination are designed to make the witness's testimony appear unreliable or untrue, or to raise doubt in the jury's minds. After the conclusion of all testimony and evidence has been introduced, each side will make their closing statements. And then we get to the verdict. This is when the jury goes off to think over the decision, to reach a verdict. They must have beyond a reasonable doubt. That means all but certain before you can convict. All but certain, beyond a reasonable doubt. The jury verdict must be unanimous. The acquittal must be 12-0. The conviction must be 12-0. A hung jury is when you cannot get to a unanimous verdict, and then the judge declares a mistrial. The verdict must be unanimous. In a mistrial, the prosecution must then decide, okay, do we try this case again? Do we drop the charges? Maybe we'll try a different plea bargain. Of course, if it is retried, it will be with a different jury. If the jury feels that the prosecution has not proven its case, it can decide on an acquittal. That's the vote of not guilty, an acquittal. And then once the accused is acquitted, you are free to go. Remember, the Fifth Amendment does prohibit against double jeopardy. The prosecution cannot appeal the verdict. The defense can, but the prosecution cannot. If the defendant is found guilty, the judge will set a court date for sentencing, or the defense can appeal the verdict to an appellate court. The judge determines the sentence, not the jury. The judge, as part of his role in the courtroom. In terms of sentencing, they often specify a time in prison. Sometimes victims of crime are allowed to make statements about what they would like to have done. Also, the judge may even ask the person found guilty to make a statement. Take that into account. Not all statements involve jail or prison time. For minor crimes, it could be probation, could be fine, it could be community service work. These are for maybe misdemeanor crimes. So, again, here's a nice chart that takes you through the procedure in a criminal case, from arrest to preliminary hearing, indictment, arraignment, trial if you don't have a plea bargain, and then either an acquittal or sentencing. And that's our procedure in a criminal case, Lesson 45. Lesson 46 will take you through the procedure in a civil case, in a lawsuit.